welcome back to Wills, Trust, and More. And of course, we have Eileen Kerlin Walsh with us. Eileen, welcome back again.
Thank you. Delighted to be here.
Eileen
Hello.
is a business person, of course, in Worth and 113th in Harlem. And she's been kind enough to come in with us on our show to talk about today a very, very sensitive topic. And I have some notes here. Many of the viewers belong to community associations. Associations meaning you're in a condo and the condo has an association. And Eileen has mentioned that there are advantages to shared living, but a lot of vulnerabilities come with that. And we want to talk about that. And what does that mean to you? And what does it mean to the association? And how is this properly structured? And who should do what and when they should do it? Eileen, we need some help.
Lovely.
I'm sure
Wonderful.
there are viewers that are looking at their situation and saying, well, what are the goals? What should we be doing? What should the association be doing? Can you help us with that?
Yes. We're certainly going to talk about the more today, the Wills, Trust, and More. Condominium law is a really interesting, very essential area of law that applies to many of our viewers. So I'm delighted to talk about it a little today. The common goals of this shared living should be a wonderful, peaceful society that everyone gets the benefit of the shared living. We want good, robust financials. We want good, available amenities. We want everyone paying their assessments. We want nice, trouble-free meetings. And we just want everyone enjoying this environment without argument, without headbutting, and everyone really getting the benefits of this, because this is a tremendously beneficial, peaceful way to live. There are a lot of advantages. There's a lot less of the trouble and disadvantages of maintaining your own residence, but it comes with some very special duties and responsibilities, and everyone has to be aware of those, become educated with them, and live by those. Take that seriously so that the benefit of this form of living can be available for everyone.
Okay, what kind of laws and documents and procedures that maybe a board should follow to support their population?
Okay, so we have many tiers of governance in this type of an organization. First, of course, you have the federal and state law that everyone has to follow, no exception there. There are three main statutes in the state of Illinois that govern this type of living. We have a Condominium Act, a Community Association Act, and then the Non-for-Profit Corporation Act. And those are the go-to documents. Now, most associations will at some point bring a lawyer on board, hopefully sooner rather than later, because a stitch in time can save nine. And then they can become very familiar with what those laws are, have copies of them, and know what part of that law that they must follow. The second tier is the governing documents. All associations will have their declarations. The board must know what those declarations are. Are there any amendments to them? Are they keeping up to date with them? Do they need to be amended? Then there are bylaws. There may be updates to the bylaws. Then there can be properly executed rules and regulations. Then there are policies and procedures to follow. So there are a lot of governing documents, and it is vital for any association to run well and for the board to run well that everyone becomes educated on them. When it comes to the finer points of the law, that's where we bring on board an attorney who's familiar with this area of law. This is a niche area of law. I have learned from the master. Alan Wishover, whom I associate with in condominium practice, has been in this practice for many, many years, since the inception in 1969. So everything that we have to face, he has already had some experience with. So when it comes to the federal and state law, we want to get some advice, maybe from an attorney. Then when it comes to your own documents, we're responsible. The association is responsible for knowing those documents, at least the general outline, at least what the rules are, what is a violation, and most importantly, if you do notice a violation or one is brought to your attention, what is the procedure? You've got to give proper notice. You've got to give that person an opportunity to be heard before they start getting fined, because that's the proper procedure. And for an association to run smoothly, knowing the procedures and following the procedures has a much better chance of any difficult situation to be resolved quickly, easily, and less expensively. We want to spend as little money on attorneys as possible. I say that as an attorney, but a stitch in time absolutely saves 9. We can come in, talk to maybe a new board, look at their documents, make sure that they're complying with them, see if they do need any updates. Do they have bylaws? Does everyone know what those are? How are the meetings being conducted? Are we following certain rules of order? All of this can really make for a nice, solid foundation to prevent some of the problems some associations do find themselves encountering.
Right. And, you mentioned a couple of things. Do the people that are owners of their condos, do they understand all these documents? Do they know what their rights are? Well,
that's the board's responsibility, I feel. The board, if we look at this, the tiers, the lawyers have to know the law. The management comfort, if it's involved, really has that strong responsibility too. When it comes to the board, they must know the declarations. They must know what the governing operating agreements and rules are. And then it's their job to educate the homeowners. So if somebody just buys a new unit, it's a really good idea for the association to sit down with them, make sure they have their copies of the documents, make sure they understand them, point out certain things. I think there's slightly less responsibility for the homeowner or the unit owner to know every single thing that's in those declarations. But if you ever elevate yourself to the level of being on the board, then there is a slightly higher duty with those laws. But it's the board's job to make sure that the unit owners understand the laws, know how many meetings there is, how to attend, how to get an agenda put together. If you have an issue, how do you let the board know? One of the problems that we often see is this ambush of a board at a meeting with a certain unit owner's issue. But if that unit owner knew that they could have submitted a request, made a recommendation, got it on the agenda, then they would be able to have it addressed at a meeting rather than bringing it up, the board not being prepared to deal with it, not having the time and agenda for it, them to feel unheard and unhappy, and the board to have had an interrupted meeting. Meetings which we agreed we would talk about today have to follow order. If we want good attendance, and we do, because at meetings a lot of things get decided upon, they must follow a certain order. They must start on time. They must follow the agenda. If there's a certain amount of time for an owner's forum, make sure everyone knew that that forum was there, that that's when they get to have their say. Someone must lead. Cut it off when the time is up. Get to everything on the agenda, wrap it up in time. Then the unit owners will come back, and we want them at the meetings. We want this to be a community. It's not just a board of dictators and sheep following. It's not a landlord just collecting rent. When the unit owners go to these meetings, they're going to understand what their money goes towards. They're going to understand what maintenance means. They're going to know whether they can rent their unit or not. So involvement by everyone, the shared ownership, the shared living is truly shared. And then when it is, we can have a really harmonious association.
The problem is that some of the associations have board members that are really not savvy with the law and what the homeowner's rights are. So then it turns out to be a yelling session at some of these meetings. So it's very unproductive.
Absolutely. And this is where we have to have some compassion and understanding. Those board members are volunteers. They have volunteered their precious time to govern this community. Mm-hmm. That has to be respected by the unit owners. But those board are now in a position of power to make decisions, and they have a tremendous duty. So they must use that duty well to understand. And if we do get notices out, if everyone knows what's happening, if everyone feels informed and aware and feels heard, there's much less opportunity for that yelling match. The yelling match happens when someone has built up frustration with an issue, maybe didn't know or didn't follow what the policy and procedure was with that. They get themselves to a meeting and they burst with their anger and frustration. And now you have a board who maybe didn't understand that that issue was going to be addressed, are trying to get all the other issues that everyone else is here to address, and now we have a difficult situation with someone going to leave not feeling heard or satisfied. So
Right.
the communication is absolutely vital, and the board, when they do step forward, and everyone must appreciate that time that that board gives to the governance of the association. They must appreciate the rights and duties and responsibility that comes with it. They have to become educated with that law. They must know what those policies are, and they must follow them.
And then there are updates to the law, and so the board has to stay current with that.
The board has to stay current. Sometimes there is help, and it depends on the size of the association. If the association is big enough to afford a management company, terrific help from the management company. Then often there will be a law firm on board, either retained or more often a law firm that's a go-to, that offers advice. And bringing the law firm on board is a really good idea because you can get advice. Often, if we're brought on board with either a new board or a change of management, or people know it's time, we review all the documents. Are they up to date? Are they current with the law? Is the association fully aware of what they have in those documents? Do they need an amendment? Maybe it's just a bylaw. Maybe they just need to update the rules and regulations. Maybe they thought they were following the document, but they just never read it accurately. So whatever it takes, either your own education, and then there are also wonderful associations for boards. There's terrific resources out there. There's two large associations, ACTA and CAI, that just exist for associations, for the management companies, for the attorneys, for the boards, and for the unit owners. They give them tons of information, seminars. There's lots and lots of ways to update yourself with the law. Go to a forum, ask questions. These large organizations have meetings and webinars and trade shows all the time. So again, it's precious time, but there is no excuse for a board not to be educated or be up to date, or the members. It's not always the board. They're often in the firing line because they have gotten themselves into that position. But I keep coming back to that shared community. A community is necessarily made up of the members in the board. They're all in this together. They own those properties together. It's in everyone's best interest for those property values to stay high. So everyone has this really high duty to each other, to their property, to the association, to make sure that they work in harmony and for each other's good. What often happens, Ron, is that someone becomes agenda driven, either on a single issue that really is important to them, or a board member has even gotten bored for a particular issue that they want to push forward. And that is where things really start sliding. It's the slippery slope of someone has gone to an extent that's really not in everybody's interest, because in addition to all that law we talked about, there's the common law duties that the board owes also. There's a duty of loyalty, a duty of care, a duty of a fiduciary duty. Those are tremendous responsibilities when you place yourself in that position to the interests of those around you and those you're serving rather than yourself. So these are real, we're all humans in these associations, but this is what we need to know, and this is how we evolved some of those escalating, difficult nightmare stories that you've heard about. I read an article recently in Florida. There was a unit member who killed two board members.
Oh.
Now, hopefully this is not going to happen too often or again, or we're not going to see that here in our lovely, peaceful community. But escalations like that start over not knowing about the pets or the number of pets, or not knowing that you couldn't barbecue, or could you have a plant in the balcony? These things, and when everybody is going for uniformity and everybody cares about the look, and we've sacrificed the barbecue and someone else brings it on board, it's a tremendously intimate form of living, and it has those benefits. But I, as an attorney who does real estate closings, when someone is buying a condo or a townhome for the first time, feel it's my duty to say, do you understand this type of living? Do you understand that it's not the same as buying a single family residence? You're buying into an additional form of governance, an additional level. Another thing, and again, I'm getting ahead of myself a little bit, when it comes to tenancy and dues, everybody has to pay those dues. What is often a big surprise for some unit owners is that if you don't pay the dues, it's not that you're just going to become delinquent. the board has the authority to lien your property and foreclose on that lien. You could lose your property because of non-payment of liens, not just non-payment of your mortgage. So it's a very serious responsibility when we take on this form of living. Inexpensive in many ways, not maintenance free, but less maintenance than a single family residence, but ultimately beneficial. But we have to be educated. We have to know what we're taking on. And if we walk into it not knowing what we're taking on, we need to get educated fast.
Well, if you have a situation or something in your agenda that you cannot come up with a resolution, shouldn't you, rather than get into this shouting match, have an attorney assist the board at the meeting, at the hearing, or whatever you want to call it?
Absolutely.
They should be called in right then.
Absolutely.
So that he can interpret on both sides the rights and what the association laws and regulations are.
Absolutely. A lot of alternative dispute resolution. We can mediate, we can negotiate. If there is a very difficult issue, it's not at all uncommon to have an attorney there at the meeting. And if escalation begins, the just is not going to be resolved there and then. The meeting must be adjourned. We cannot allow people to be trampling on each other's rights. So I would call for the meeting to be adjourned rather than letting it escalate where no one is benefit, and it's just tremendously upsetting to so many people. So what we would have to do, if there's something causing a meeting to escalate like that, we'll have to look at the underlying issue. What is the violation, or what is the issue? Has someone started a construction that wasn't, properly passed, or something like that? Whatever it is, it's going to have to be dealt with outside the meeting, between the parties. I always try for what we call alternative dispute resolution. Can we mediate? Can we negotiate? Can we find some common ground? Because so often people feel backed into a corner. Everyone's living together, so there can be the intensity of that you can never really walk away from the problem. But if you can let everyone know that they're being heard and that you understand their side of the story, we often can find some common ground, as well as the cost of litigation. Every board should be aware of that. That's going to come right out of the dues that are there for your reserves and for the association. That's how the attorneys, that's how the litigation is going to be paid for. So it's in everyone's best interest to not let those escalations get out of hand and turn into lawsuits. Certainly, sometimes documents will be filed, but the average lawsuit, even if it never goes to trial, and most of them do not, is going to cost about $5,000 in fees. That money would be much better spent in education and a little bit of compromise on both sides, so that it doesn't get to that point.
Okay, lastly, is there a golden rule to get to happiness and peacefulness and having successful meetings?
Happy Valley. Yes. Well, the theme for me that runs through all my work, all my practice, my motivational work, my life is compassion. And I think it's the answer here too. We've got to walk, as Alan Wishover always says, in the other man's shoes. You've got to look and see how that person feels. If you're a board member and someone keeps complaining about the neighbor or the pond or whatever it is, listen to them, hear them. If someone is not paying their dues, try to see why they're not paying. Have they just gone through a divorce? Have they lost their job? Yes, dues must be paid, but a little bit of compassion, maybe the offer of a payment plan rather than instantly starting to file something against them. Compassion and love and kindness goes a long, long way in association management, as well as in all areas of law, as well as a life. It's a tremendous life skill, it's a good business strategy, and it works beautifully in association communities as everywhere else. See the other person's side, try to have some understanding, try to get that to compassion, and maybe we can all work something out to keep us in this nice, harmonious, peaceful living situation, because it is, as we said at the beginning and we go right back to, it is a tremendous way to live. There's a lot of benefits, but we've got to also see the burden, manage it, and then get us all to that nice happy valley that all our associations can be. Right, Ron?
I hope so. I hope so.
Thank you.
What I wanted to say to the viewers, that if you are the association or you're a homeowner, property owner, we'd like to say that if you have any further questions, maybe you could call Eileen with the question, and we're going to put her number up at the bottom of the screen and her address, 1 1301 Harlem Avenue if you want to stop in and see her and talk to her associates, and maybe they could help answer some questions. But most of all, if you have a question on this topic, give Eileen a call and go from there. We're going to have another interesting topic again the next time, and I'll be looking forward to getting together with you. We wish everyone, hopefully, that they got something out of this session, and we can continue with wills, trusts, and more in the future.
Next time. Thank you, Ron. Thanks so much. Thank you.